Marriage is a union between people that is recognized by law and culture. Around the world, the rules for marriage can be very different. In many Western countries, the law states that a person can only be married to one other person at a time. This is called monogamy. It is the most common form of marriage legally recognized in places like Europe and North and South America. These laws are often based on long-standing civil and religious traditions that have shaped their societies for centuries, creating a legal framework that supports a two-person marital structure as the sole acceptable form. However, this is not the only type of marriage that exists. In some parts of the world, a person is allowed to have more than one spouse at the same time. This practice is known as polygamy. Specifically, when a man has more than one wife, it is called polygyny. This form of marriage is often connected to a country's religious, cultural, or traditional history. It is important to understand that the legality of polygamy is not universal. It is permitted in some places, but is against the law in many others, reflecting the diverse legal and cultural landscapes that govern personal relationships across the globe. The laws governing polygamy are complex and vary greatly from one nation to another. Even in countries where it is allowed, there are often specific rules and conditions that must be met. For example, a man might need to get permission from his first wife before he can marry another. In other cases, he might have to prove to a court that he can financially support all of his wives and children equally. These regulations are designed to provide some protection and ensure fairness within polygamous families, showing that the practice is not just a simple matter of personal choice, but is governed by state-sanctioned rules. Understanding these different marriage systems helps us see the rich diversity of human cultures. What is considered a normal family structure in one part of the world might be very different from what is accepted in another. These laws are not static. They can change over time as societies evolve and as debates about family, rights, and religion continue. The global conversation about marriage law is ongoing, with each country navigating its own path, based on its unique history, religious demographics, and social values. This essay will explore where polygamy is legally permitted, with a special focus on nations in Asia and Oceania. In Asia, several countries have laws that permit polygamous marriages for all or some of their citizens. These laws are often rooted in a combination of religious and cultural traditions that have existed for a very long time. For instance, countries in the Middle East, which is part of West Asia, broadly permit the practice. Nations such as Saudi Arabia, the United Arab Emirates, Qatar, Oman, and Yemen have legal systems influenced by Islamic law, which allows a man to have up to 4 wives. In these countries, polygamy is a legally recognized and socially accepted form of marriage, integrated into the civil and family law codes. Moving eastward into South and Southeast Asia, the legal landscape remains varied. In Pakistan and Bangladesh, for example, polygamy is legal but regulated. A man who wishes to take another wife must get written permission from an arbitration council, and he often needs the consent of his existing wife or wives. This adds a layer of official oversight to the process. Similarly, in Afghanistan, polygamy is legally permitted. These regulations, while allowing the practice, attempt to introduce measures of control and fairness, distinguishing them from places where the practice is unrestricted by state intervention. In Southeast Asia, countries like Malaysia, Brunei, and Indonesia have dual legal systems. They have civil laws for the general population and separate Islamic laws for their Muslim citizens. For Muslims in these countries, polygamy is legally permitted under Sharia court jurisdiction, but it is typically subject to strict conditions. A man must often demonstrate his financial capacity to a religious court and sometimes get the approval of his current wife. This dual system approach allows the state to accommodate the religious practices of a significant portion of its population while maintaining different laws for non-Muslims. In the region of Oceania, which includes Australia, New Zealand, and numerous Pacific Island nations, polygamy is generally illegal. The legal systems in Australia and New Zealand, for example, are based on English common law, which strictly defines marriage as a monogamous union. However, some smaller island nations in the Pacific, such as the Solomon Islands, legally recognize customary marriages, which can sometimes be polygamous. This recognition of tradition exists alongside the formal state law, creating a situation where polygamy is not permitted under civil law, but may be tolerated or accepted as part of customary practice for certain indigenous communities. Many countries that do not generally allow polygamy have made special exceptions for their Muslim populations. These nations often have a dual legal system, where civil law applies to the general populace, but Islamic family law, or Sharia, governs personal matters for Muslims. This allows Muslim men to practice polygyny in accordance with their religious beliefs, even when it is illegal for other citizens. India is a prominent example of this structure. While polygamy is a criminal offense for most Indians, the Muslim Personal Law Shariat Application Act of 1937 allows Muslim men to have up to 4 wives without legal penalty. Similarly, in Southeast Asia, this dual legal framework is quite common. In a country like Singapore, the general law of the land, based on the Women's Charter, prohibits polygamy. However, the Administration of Muslim Law Act, or AMLA, provides a separate legal system for the Muslim community. Under AMLA, a Muslim man can apply to marry a second, third, or fourth wife. He must submit an application to the Registry of Muslim Marriages and prove that he has the financial means to support all his families and that his existing wife or wives consent to the new marriage. The Philippines also follows a similar model, accommodating its Muslim minority, who are concentrated in the southern region of Mindanao. The country's family code prohibits polygamous marriages for the majority Christian population. However, the Code of Muslim Personal Laws of the Philippines, also known as Presidential Decree No. 1083, explicitly recognizes and permits polygamy for Filipino Muslims. This special law governs matters of marriage, divorce, and inheritance for the Muslim community, allowing them to follow practices that are central to their interpretation of Islamic tradition, separate from the national civil code. This legal pluralism, where different laws apply to different religious groups within the same country, is a way for secular or multi-religious states to manage cultural and religious diversity. It allows minority communities to maintain their unique traditions and religious obligations regarding family life. However, these systems are also the subject of ongoing debate. Critics raise questions about equal rights and protections for women under different legal codes, while supporters argue that these provisions are essential for guaranteeing religious freedom and preserving the cultural identity of Muslim communities within a larger, non-Muslim society. Beyond civil and religious laws, there is another important category of rules that can permit polygamy: customary law. Customary laws are traditional, unwritten rules that have been followed by a particular community or ethnic group for generations. In many parts of Asia and Africa, national governments formally or informally recognize these customs, especially in rural areas where state institutions may be less influential. This means that even if a country's civil law forbids polygamy, it might still be practiced and considered valid within a specific tribe or community under their own traditional legal system. For example, in some parts of Indonesia, outside the scope of Islamic law, certain indigenous communities have long-standing traditions of polygamy that are accepted as customary practice. The state may not officially record these marriages, but they are recognized and respected within the local community. Similarly, in South Africa, the Recognition of Customary Marriages Act of 1998 legally acknowledges customary marriages, including polygamous ones. The law requires that all such marriages be registered to ensure the legal protection of the wives and children, blending traditional practices with modern legal safeguards. This recognition of customary law is also prevalent in several other African nations. In countries like Kenya, Zambia, and Uganda, customary polygamous marriages are legally permitted alongside civil and religious marriages. These laws acknowledge that for many communities, family structures have historically been polygamous and that forbidding the practice outright would conflict with deeply ingrained cultural norms. By giving customary marriages legal standing, these governments aim to protect the rights of all spouses and children involved, ensuring they have claims to inheritance and property that they might otherwise be denied. In summary, the legality of polygamy is not a simple yes or no question. It is deeply intertwined with a country's specific legal, religious, and cultural context. While many nations strictly enforce monogamy, others permit polygamy for all citizens, often under Islamic law. A significant number of countries have created special legal carve-outs, allowing the practice only for their Muslim populations or for indigenous groups under customary law. This complex patchwork of laws shows that there is no single global standard for marriage. Instead, each nation balances its history, traditions, and modern legal principles in its own unique way.